Welcome to the Case Storm TV, where we explore the legal nuance surrounding trials, hearings, and criminal proceedings. In today's episode, we return to the Harris County Criminal Court in Houston, Texas, where judges are once again asked to decide whether the state has met its constitutional burden to establish probable cause. Across several recent hearings, the court evaluated whether criminal charges against multiple defendants were supported by sufficient evidence, with each case raising a different question about what the law actually requires before a person can be prosecuted. This episode is part of our ongoing series dedicated to helping our viewers understand how probable cause materializes in the courtroom, particularly when evaluated by a competent and impartial judge. And throughout today's case, we will carefully explain every statute, every article, and every regulation that comes into play, so you don't just watch the hearing. You understand it. If there are any probable cause cases you'd like to see included in this series, let us know in the comments below. And with that said, let's dive into our first case. On March 20th, 2025, Defendant Juan Jose Cerna was brought before the court on a charge of burglary of a motor vehicle arising from an incident in the Old Navy parking lot in Harris County, Texas. Mr. Cerna now stands before the court for a probable cause hearing, where the judge must decide a single, critical question.
Is that on or about May 18th, 2025 at the location of Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, that you were in possession of drug paraphernalia? Do you understand the nature of that charge, ma'am?
Yes.
That's a misdemeanor, punishable by up to 90 days in jail, $500 fine plus court cost, and any substance abuse counseling the court deems necessary. You understand?
I think Mr. Stiller's on some of the other cases, but sorry, Mr. Stiller, handling much stuff. Good afternoon, or good morning, Assistant Public Defender Lauren Perning on behalf of Mr. Dunlap on the cases ending in 0353 and 0354.
Good morning, Your Honor. The pleased dishonorable court, Brandon Bird on behalf of Vincent Dunlap on the case ending in 0589.
All right. And what are we doing?
Oh, Your Honor, respectfully, got to speak with brother prosecutor and counsel over here, and we would like to plead all three cases to the civil infraction of a double parking.
Right here, this is a classic example of plea bargaining at the lowest level. Instead of risking a misdemeanor conviction, the defense negotiates all three cases down to a simple civil infraction, double parking. Under Michigan civil infraction law, civil infractions are not crimes, meaning no criminal record, no jail time, and far lighter consequences. This is strategy, not luck.
That's correct, Your Honor.
Yeah, there's a state case that wasn't part of any resolution I was involved in negotiating.
I'm not a prosecutor. Tell fraud is. I'm only a prosecutor for review.
That's why I thought I spoke with you earlier. Awkward. Your Honor, respectfully, can we adjourn this matter to see how his other felonies play out? I know his preliminary exam got pushed back. Last time we adjourned it to see what was going to happen.
Do you want to adjourn yours out?
Please, Your Honor.
I have July 16th or August 6th, which is the preference if you're trying to time it up with an exam date.
July 16th, Your Honor.
July 6th. This being case 589, I'll adjourn that matter to July 16th, 2025, 9 a.m. Bond on that matter will continue.
Notice what the judge just did here. By adjourning the case and continuing bond, the court is exercising discretion under Michigan Court Rule 6.004, which allows judges to manage scheduling when other felony matters are pending. Translation: the judge is waiting to see if those felonies explode before deciding how serious this case becomes.
My cases are the cases with Mr. Stiller, Your Honor, so I would, we are going to...
Double parking on both.
Correct.
And double parking in each case, Your Honor. Going to move that count to in each case, double parking. If you accept that admission fee in each case, and it's just the original charge in each case.
That's a correct statement.
That is, Your Honor. Thank you.
Mr. Dunlap?
Yes.
In the case ending in 353, do you admit responsibility to the fact that on April 2nd, 2021, Pittsfield Township, that you double parked a motor vehicle?
Yes.
on the case ending in 354 on the date of April 2nd, 2021. Do you admit responsibility to the fact that you double parked a motor vehicle in Pittsfield Township?
Yes. This is a textbook plea colloquy. The judge confirms the defendant is knowingly admitting responsibility, as required by Michigan Court Rule 6.610E. And look closely, count 1 is dismissed. That's not generosity. That's leverage. The court trades dismissal for a clean, fast resolution.
Court will accept those admissions in each case. Count 2, count 1 is dismissed. In each case, fines and costs are $180, so that's total amount of $360. That's to be paid 60 days. I'll make it 90 days after release.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Juliet von Oceanbear Martinez. This is Mr. Siller's case. All right. Ma'am, can you state your name, please?
Devin Julia Martinez.
All right. Pardon? Yes. Mr. Martinez, this is an arraignment on a misdemeanor complaint that alleges that on or about May 18th, 2025, at the location of Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, that you were in possession of drug paraphernalia. Do you understand the nature of that charge, ma'am?
Yes.
That's a misdemeanor, punishable by up to 90 days in jail, $500 fine plus court cost, and any substance abuse counseling the court deems necessary. You understand that?
When the judge explains 90 days jail, $500 fine, this isn't casual talk. Under Michigan Compiled Law Section 333.7403, possession of drug paraphernalia is a misdemeanor with exactly these statutory maximums. This is the court formally advising the defendant of her constitutional due process rights before any plea can even be accepted.
Thanks.
All right. And my first question to you is, do you want to be represented by an attorney?
It isn't
Pardon?
necessary. It isn't necessary.
Is it necessary?
It isn't necessary.
Well, it might be.
I said it isn't necessary, so could I just speak for myself?
Okay, what do you want to do on the case?
Just let me think.
Hey, Ms. Martinez,
Yeah.
are you still, you had other cases a while back. Are you still on probation on those cases?
No.
Okay, so you're not before the court, a court on any other things?
I am, but none of them are drug related, and they're about to be finished.
Well, maybe. What other courts are you before, Ms. Martinez?
Is it necessary to expound upon this?
Pardon?
Is this relevant?
Well, it could be, because you could be facing additional sanctions depending on those cases, depending on what happens in this case.
Well, is there any way to live this down? Like, have it like
To do what?
have it go, like, is there any way to like forget about this somehow? Is there anything that I can do, like community service or something that I could do instead of
Ms. Martinez, you don't have.
This moment is critical. The judge is protecting the Sixth Amendment to the U.S. Constitution, the right to counsel. In fact, under Gideon v. Wainwright, 1963, and Michigan Court Rule 6.005, the court must ensure any waiver of an attorney is knowing, intelligent, and voluntary. The judge is basically saying, without a lawyer here, you're walking into a legal minefield.
That's why I think you would need an attorney. I mean, you can proceed on your own if that's what you want to do. But quite frankly, knowing a little bit about your history, I don't know that would be a wise call on your part.
So, like what, like, I suppose.
Ms. Martinez, just answer me this. Are you represented by the public defender's office on your other matters?
Yes.
Okay, don't you think it might be wise if they help advise you on this matter and also help you with those other matters? Doesn't that make sense to you?
In a way.
In a way. Okay, in a good way?
In a way that is like, I can, have this, be adjourned with a bond? Can I know what the bond is?
Ms. Martinez, I don't even have a plea from you at this point.
Oh, please, I'm guilty.
No, I didn't mean that.
No.
So,
I'm not protesting to the allegations. I would like to just.
but hold on. I don't want you saying anything about the offense.
Well, I do. I see no way around it. It's plain and clear and simple.
Well, I know that's why people get attorneys, because sometimes they don't see any way around it.
But it's clear. It's plain. Like, really.
Oh, I don't know that, Ms. Martinez.
Yeah, I guess I'll go with a lawyer. Sure.
You will? Good. Okay, public defender case.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Martinez, Your Honor, we would waive any further reading. My client stands mute and ask that a not guilty plea be entered. I would ask, Your Honor, for an adjourned pretrial date. However, a more lengthier adjournment. The public defender does represent Ms. Martinez on her other matters. She actually has been referred to the Forensic Center and does have an appointment today with them. So I would ask for a lengthier adjournment to that end, Your Honor.
You should have led with that. All right.
The appointment is today?
When she has the appointment today?
It's scheduled for today per the letter from the center.
Got it. Do you know when the hearing date is set on the other matter?
Her latest court date in circuit court is July 28th, and her bond is denied on that case. So I believe it's the 28th.
Okay. So what I will do is I'll adjourn this matter out to August 6, 2025, 9 a.m. I'll set the defendant's bond so that she's getting credit because she's being held on that other case. I'll set her bond at a $5,000, 10% bond on this case. Order standard conditions, including no assaultive behavior, no alcohol, recreational marijuana, or any illegal drugs. All right. Thank you.
Here comes the real consequence. A $5,000 10% bond means she must post $500 cash to get out, but only if she's not already being held on the other case. Under Michigan Compiled Laws Section 765.6, bond is about two things: court appearance and public safety. And right now, the judge is clearly worried about both.
Thank you, Your Honor. Thank you, Ms. Martinez.
It says on the Forensic Center is coming to see me today.
It's scheduled for today, but I'm not sure if maybe I don't have the most updated information. So there's a chance it might be rescheduled, but from what I can see, it looks like it was scheduled for today. But either way, we'll be in touch, Ms. Martinez. But you're all set for court here today.
What is your name?
We're all set for court here today, Ms. Martinez, but I'll be down to see you before August.
Okay, but what is your name?
Oh, sorry, Natalie. I did not hear. I apologize. Natalie.
Natalie who? Natalie who?
Natalie Pate.
Pate. Thank you.
All right. Thank you.
Thank you, Ms. Martinez.